And we are live. Can somebody confirm, please, if we are live? I don't think so. There's just one person watching, which is probably me. Hi, Mathlodi. How are you?
Hi, Sister Tammy, I'm good and yourself.
I'm fine. We're just looking to find the right link to send to everyone that we are live.
We are
And for
live.
some reason, yes, we are. I just can't find the link. Oh wow, technology can be good. It is good. We just need to know what we're doing. Ah, so
I agree.
yes. Okay. We are live. Okay. I can see we've got 4 people watching. Hi everyone, how are you? Uh this is Wheels and Trust with Matt Lodi. We just had some technical issues, so I do apologize to everyone. But we're here now. So today we're going to be talking about wills and trust. Huh? So, Mathlodi, we had a beginning somewhere, but we were not able to actually get to the nitty gritty of wills and trusts. So today you're going to help us in breaking it down so that we can not be afraid of it anymore and do what is necessary. So before we begin, I know we don't like to talk about death, but it's something that happens to everyone. And because of that, we need to deal with it. So, seeing that I am not the expert here, I'm going to give it to McLeody to go with it. We will first we'll let McLeody tell us what we need to know. And then please have your questions ready. Then we'll open it for questions and answers. Okay, over to you, McLeody.
Thank you, Sister Tammy, and thank you for this opportunity to talk about a very necessary yet the one topic that most people seem to be scared of. But I think,
Yeah.
just to lighten up a little bit, I
Yeah.
found it interesting and very apt that we're having this conversation on Heritage Day. Um,
Yes. Happy Heritage Day, everyone.
Yes. In preparing for this session today, I was reminded of a scripture in Proverbs 13, verse 22, that says that a good man leaves a heritage and inheritance for his children's children. And I thought, what an appropriate day, particularly for us in South Africa, to be having this conversation, talking about the importance of building an inheritance and
Mhm.
generational wealth for one's children other than on this day. So I think it's a worthwhile conversation, and I'm excited to be taking part in this.
Thank you.
Thank you.
So you said I should look for my questions, and then I had like a million questions to go. So let's start with what is a will? Because at the women's thing, people were asking some questions that I thought I knew the answer, but from what I was hearing, it's different from what I thought it was. So can you tell us first what is a will, and then what is a trust?
Okay. So a will is a legal document that, as I said during the Women's Day about 2 months ago, that it's
Mm-hmm.
essentially a document where you are deciding who gets what, literally who gets to
Okay.
inherit what assets that you have. As I said, it is a legal document, and so it must meet certain legal requirements for it to be regarded as a valid will. So in your will, you get to state what your assets are, get to state who your beneficiaries are, and what they are to receive or inherit from your estate after your death.
Yeah.
You get to choose an executor. An executor is a legal term which literally means somebody who is going to administer your estate after your death. A
Okay.
will, if you want to take it a step further, is also a document in which you can also create what is called a testamentary trust. Now,
Okay.
I know that we will get into the topic of trust a little bit later on, but just broadly, there are two different types of trust in our legal system. We have what is called testamentary trust, which is that which
Okay.
is created in a will. And then we've got what is called inter vivos trust, which is created by means of a legal document. and that type of trust, interviewer's trust, comes into being after during the lifetime of the founder. So, in essence, a will is a document in which you decide who inherits what, and also who the executors are of your estate.
Okay, let me ask a funny question. When is the right time to say for a will?
Uh, I always say at any time. So by in terms of the law, anybody above the ages of 16 can actually put a will in place. And I
Really?
suppose, yes, and I suppose this comes from the medieval times when, 16-year-olds, I mean, in those times, I suppose they would have started to acquire wealth. But I think it also has got to do with what is called the age of legal capacity. So from the age of
Okay.
16 in most legal system, somebody who's 16 years of age is regarded as being of legal capacity, and so they can execute a will. But then I suppose, your next question is going to be, you've got a 16-year-old, they stay with you in the house. What do they
Mhm.
and so, we take it a step further by saying that, anybody with assets, anybody with family members that upon their death, they want certainty around who's to inherit what, can actually
Okay. Yes. I didn't know the legal age for capacity is 16. I thought it was 18.
So that's a good question. See, we're going deeper. So we've got the Children's Act that prior to the Children's Act being enacted, I think in 2008, the legal
Yes.
age of majority was 21, but it was reduced
Okay.
to the age of 18. So it is very much at the moment in our legal system a statutory age of maturity, which is 18. But I mean, in common law terms, from the age of 16, one is regarded old enough to take care of your own assets. But of course, that is debatable. So, yeah.
Okay. So let's start with my questions. Okay. So that we can get everybody into the on the same page. I do wonder though, if the age of capacity, sorry, let me take it back a little bit. If the age of capacity is 16, does that mean if a 16-year-old signed any document, it's legal now?
Well, so yeah, no, that's a good question. So I will say this to you. So it is only in terms of the Wills Act that a
Okay.
16-year-old is regarded as having a legal capacity. But any other legislation, or even in terms of common law, one does not or is not deemed to reach the age of majority up until they're 18. So up until one is still 18, they still need legal assistance. They still need to be assisted by a guardian.
Okay. Just like the question I'm reading now, a 16-year-old still live with a parent. So what could they possibly have that is theirs? I mean, unless they've divorced their parents, like some kids are doing now. Just to answer what could they possibly have that is, theirs?
So for the most part, they don't have anything. So for the most part, as I explained, this concept of or the idea of a 16-year-old having the
Mhm.
ability to execute a will really, really comes from the olden times when
Okay.
during those times 16-year-olds could get married, they could go to war and that kind of thing. And I think it comes from that, from the fact that at that time in those medieval times, 16-year-olds could actually go to war. And, yeah.
Okay. So what does a will do? I'm
Um,
asking this. I mean, we generally have a knowledge of what a will is, but what does it do? Because I'm going to take this and go to when people start fighting over a will. So what does a will do? Let's start with what does a will do?
a will lets people know who is inheriting what. A will lets people know, particularly your family, what your wishes are. So to break it down, one will say in a will, after a person's death, after a person's demise, um, I want to be cremated or I want to be buried.
Okay.
I
Mm-hmm.
want to be buried in this place. I want to be cremated and my ashes to be scattered at a mountain, wherever you want. A will lets people know the last wishes of a person who just passed away around where they want to be cremated,
Okay.
who inherit what. If they have got minor children, who is going to be the guardian of the minor children. A will lets them know, perhaps I've got properties. Do I want them to be sold? And who I want to live in my property and on what conditions.
Okay.
Provided, I must say, provided that those conditions are legal. So that's what basically a will does. A will gives certainty to the family members who remain behind after a person's death as to what
Okay.
happens. A will is
Mm.
also a vehicle of generational wealth planning because in my will, I could direct that I want a trust to be created for my minor child, and the trust
Mhm.
must pay for the following his education. A trust can say, it must fund him when he wants to start a business. And then the trust must terminate maybe when my son is married with five children and he has proven himself to be responsible. So that's what a will does. A will,
Okay.
as much as we say that a will is not an instrument of people ruling from the grave, but a will helps to ensure that the wishes that you have for your family are carried out.
Okay. Kakiso is asking my next question really. Um, so you leave your wishes, this is what I want, this is what I want to do. So on what basis do people contest the will? Because you know what you want, you know where you want your things to go. Why would then be a loophole? That's what I see in it for people to contest it. I mean, if you're of sound mind, because I see it always says of me of sound mind, blah blah blah. So why does it always have that? Why is that loophole that you can contest it?
Well, the most reasons why people would contest a will is because they would believe that the deceased parent or family member did not execute that will. So the most grounds for disputing a will is if the family member of a person who just passed away say the signature on this will does not look like that of my dad or of my mom, or
Yeah.
I don't believe that when he was stipulating his wishes to the drafter of the will, he was of sound
Mm.
mind. Or one will
Okay.
say that I believe that he was being influenced.
Okay.
Let's say between siblings, the one siblings will say that I believe that my mom or my dad was being influenced by the other siblings or other family members. So that is generally the reasons why a will is being disputed. Or if you believe that the person who is making a will, called the testator in our law, did
Okay.
not apply his mind, particularly to the minor children. And you're
Hmm.
saying, for that reason, I've got every ground to take it to the High Court to dispute the contents of the will.
Okay.
Yeah.
So we've laid the ground, and that is what a will is and all of that. What about, okay, let me go before I go to the next question. In the will, you say you want to be cremated, and your family members don't feel that way about the dead. You know, this not the same. I'm saying that because I it is actually personal to me. What happens then? I mean, it's not like the ghost is going to come out and chase everybody.
You
But
know,
what happens then?
yeah, that's a very good question because it's the practicality of what you're putting in a will. And that's
Hmm.
why for most practitioners in this field or industry of
Hmm.
ours,
Yeah.
they recommend that you must actually have a conversation with your family, because the truth
Hmm.
is an executor is not going to enforce that your body was cremated, because here's what happens: a person passes away today and
Hmm.
the family only gets to know about the will a month later or 2 weeks later. And generally in our society, a funeral of a deceased body takes place within a week, right? So the executor is really not going to be there to enforce it, but it helps to have had a conversation with your family that, look, I wish to be buried in this place, or I wish to be cremated. And but in essence, I've never come across any case law where the deceased person wanted to be buried or cremated and the family had other
Mm,
wishes. um it's generally, yeah, it is hard to enforce unless if he is tying his bequest, that is an inheritance that is leaving to family members, to his wishes of either being cremated or being buried, to them fulfilling his wishes, which is
okay.
quite hard to enforce. So it is a good question that you're asking. And so
Mm,
my guidance and advice to people out there is, have conversation with your family. Don't leave it to chance. Let them know where you want to be buried, or whether you want to be cremated. Let it be a known thing, so that what is contained in the will is actually something that your family particularly knows about.
okay. Thank you. So if a 16-year-old can write a will, that means anyone over 16, whether single, married, can have a will. Okay. Because I'm looking at some of the questions that I already have here. If you have you're single, you have kids, and I'll be honest, or rather, will be realistic. Sometimes the kids these days are from different parents, or you're from a
Mm.
blended, or you're in a blended family. There are all kinds of family these days. Can you have a will that states, this is what is going here, this is what is going here? I'm saying this because traditionally, actually where I come from, there's a way they divide things traditionally. Will that traditional way of distributing your wealth when you're gone, will it affect your will, or will the will supersede whatever traditional way of doing things will be? Which one will
So,
take
so
precedence?
okay, so let me answer it this way. In South African law, we've got a principle called freedom of testation, which
Okay.
says that I can decide. The law does not dictate to me what I put in my will. So the only proviso, or the only condition to that freedom of testation, that is accorded to every person who is of legal capacity to execute a will, is that it should not be against public morals. Now, when you are asking me about whether can my religious beliefs
Mm.
supersede my will, the only condition is if it is not against public morals. An example: the law will not recognize a bequest or an inheritance or a request made in a will if it is attached to me killing somebody, to me breaking a law. So,
Okay.
provided that your chosen faith does not contradict public morals, um, then your will, um, or what you're putting in your will, can supersede any other request, provided that it meets with the conditions of public policy or morals. And if
Okay.
we look at where this concept comes from, much of it takes its tenets from many of the religions of the world. You will not kill somebody, you will not cause public harm, and that kind of thing. And then
Mm.
the other question that you asked me is it advisable that if I'm in a blended family, um, I've got kids from a previous relationship, and I'm married, and in this marriage, there's children, and my husband, he's got children from a previous marriage, and we're that blended type of family. Then it is even more advisable that you have a will in place, because it is a vehicle through which you create certainty, as I said
Mhm.
earlier, as to who is going to inherit from your estate.
Okay.
You might want to limit how much your stepchildren inherit from your estate.
Hmm.
You might want to be more specific to say, in this marriage, despite the fact that both the husband and the wife have got children from previous marriages, but in this marriage, in this union of theirs, they've
Hmm.
got minor children. you might actually want to create a space where you are leaving a larger inheritance for the minor children. And even more better that you do that. Because if you don't do that, you then are leaving room for what we call Interstate Succession Act to come into
That
play.
was my next question. Okay, go on, please.
And that means that, it operates on the principles of equality, because it will say if a married person passes away, the husbands get a certain amount, and what remains after the husband has gotten that, children born of the marriage, even children born out of the marriage. For instance, if a woman passes away and she came into the marriage with a child or two, and then in the
Okay.
marriage she had two other children, are going to inherit on an equal basis. And that might not serve the purposes of estate planning, because you might have minor children whom you actually want to have to leave a little bit more inheritance to, because they
Okay.
still need to go to varsity and that kind of thing, or they're still finding themselves in life. So it is absolutely necessary that for those who find themselves in blended family situations, that they actually apply their minds as to what must be contained in their will, and also apply their mind as to what portion, they, particularly the minor children, what they are to inherit.
Okay.
Yeah.
Okay, I guess that so that is what the interstate succession law is. That's actually a
Yes.
bit like what I was saying, because traditionally you would have there's a way they'll say in blended family especially, you have two wives, for example, and you have 10 children, but it's not 5 5, maybe it's 3 4, sorry, it's 3 7 or 6 4. Some will say everybody gets the same thing, whether you're the oldest or the youngest, everybody gets it. We just divide it into 10. And then some will say, no, 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 we can't do that. We divide it to two. This is for
Yeah.
this wife and her children. This is for this wife and her children. So we actually have had blended family for a while with us. Ah, okay. So how do I safeguard my hard earned assets for my family? I guess I'll be going into trust, wouldn't it?
Yeah.
If we
So
say
so
that, I don't want us to go into trust yet, but is that going to be a trust issue? Will that
so
be setting up a trust?
it can be a trust issue, that is creating a trust, not trust as in
Sorry, that is creating, sorry, to create a trust. Okay, yeah.
yeah. Um,
Mm-hmm.
or it could easily be in a situation with a will where you
Okay.
are specific that, um, say for instance, you are married, and you got children out of wedlock that you came into the marriage
Mm-hmm.
with. You are specific to say, before I got married, I had these assets. And you become very specific that you want those assets to be left to children that you came into the marriage with. That's another way of
Okay.
safeguarding your hard earned assets,
Okay.
for your children, from this institution that you find yourself in. But I mean, let's be practical about this. You want to do it in a manner that is generous to your husband or your wife, but also generous to the children born of this marriage. So, but ideally, in such situations, again, it's about applying your mind. It's about having open
Okay.
conversations with your spouse about how you want to divide your assets,
Okay.
upon death, and have an honest conversation around why you're doing it. One of the things that I find systemic is that people avoid this conversation or topic altogether, and surviving spouses are left with surprises after a loved one has passed away, because they did not know what thoughts they had, if one wanted to leave a portion to one's parents, one wanted to leave a portion to one's siblings. But it's necessary that people have conversations about it. And so, my view is the safest way to safeguard the inheritance or your heart and assets is
Mm-hmm.
to apply thorough thinking, and do so under the guidance of a specialist in this area who will guide you, on the various avenues that are available.
Okay. On I had one question, but on this giving it to be advised by a specialist. Does that mean I can't just write on a piece of paper? I leave all my things to Mathlodi because I just like her so much. Signed Timmy. Will that
Well,
work? This is my last writing and I've signed it. Will that, if I take it to the police station, for example, and I say, okay, please authenticate this for me, will that stand as a will? Or does it have to be done properly?
so for a will to be regarded as being valid in South African
Mhm.
law context, it must meet the requirements of the Wills Act, which
Which
it
are?
must be written out, which it must be written out.
Mm-hmm.
It must be dated.
Okay.
It must be signed by the person who's making the will, the testator, and it
Okay.
must have witnesses. So
Mhm.
writing on a piece of a paper to say I'm leaving my assets to so and so, and you know you don't have it witnessed by other people who are saying I was there when
Mhm.
this was being written out or typed out. I was there to witness the signature of the person. It is dated, let's say the 24th of September 2004.
Yeah. Mm-hmm.
Might find ourselves with a situation where the master of the High Court may not accept that document as being valid. So,
Okay.
what I'm saying in simple terms is, in essence, if we think about it, if we think about the Wills Act, a will does not actually need to be typed, but it needs to be in a written form that says, on this date, I, so and so, make the
Okay.
following bequest or gift of or or inheritances to the following people. Here's how you are able to identify them. I must sign it, date it, and if Sister Temi and Pastor Kim or Pastor Tim or Pastor Kim or any person, Sis Muller in the church is available, they are witnessing it,
Mm-hmm.
then it's going to be accepted um, as a valid
So then
will.
it's legal. So I can still write it. Okay.
So you can still
Um,
write it,
yes.
but there are certain things in our law that you need a specialist for, just so that you
Mm-hmm.
don't create uncertainty in your will. So you need to, because it's a legal document, the writing of
Yeah.
it to also conform with certain legal principles. There's
Okay.
certain, scenarios that are created in the will that you will need the advice of a specialist to guide you
Okay.
as to, if I say the following, what does it mean practically? If I do this, what does it mean practically? And so it is advisable that even though you know what you want, who you want to inherit in your estate, but
Yeah.
it is advisable that you so under the guidance of a specialist in this area, just so that they guide you
Mhm.
around. Can I do this? Can I do the following? Yeah.
Okay. So that takes me to my next question. Can married couples have different wills?
Yes, they
Can a
can.
husband have a separate will from the wife?
They can. So we're not talking about we're not talking about the impact of marital regimes on wills.
Mm.
So we've got mainly two different types, or three types: a marriage in commute of property, a marriage out of commute of property, and a marriage out of commute of property with accrual. So in either of the three, when death occurs, there's what we call a dissolution of the marriage by death. So in a marriage by commute of estate, before death occurs, there's one commute of estate, one whole. When death occurs, there's a separation because now the one is no longer there, and the 50% is now belongs to the deceased estate. The 50% belongs to the spouse who's still alive. And so, in
Okay.
that sense, it's very much possible, and not only possible, but it is practical that spouses can have separate wills
Will this
because
cause a problem? Do you tell your husband I'm drawing up a will? Okay, let me be fair. So I know at least two couples who have drawn up their wills. I mean, they went together and it's like everything that belongs to me goes to you when I die. Everything that belongs, so they just swapped around. And I guess whatever is written on the first one is written on the second one. But in a situation where, for whatever reason, if the marriage is not going as it should, and one half of the couple have more things to leave behind, because that's also another thing. Um, and then they go and make a separate will without telling the wife or without telling the husband. And surprise, surprise, it's on the day that they are reading the will that you realize that actually and that's that thing as well. When you thought mom was going to leave this to you, or maybe she had said it in passing, or you thought, because we started the company together, I'm going to get it when my husband dies, or when I die, because we started the company together, my wife will get it. You don't write it down, but then family come in. So is it advised? So that's what I'm saying. Does your spouse need to know that I'm writing a separate will from whatever it is we've decided?
It is advisable that you have a conversation to avoid nasty surprises. Um, but as I said, um,
Mm-hmm.
once death occurs, there is a natural dissolution of the marriage, and so one is free to then dispose of assets that are in their name.
Okay.
But it is highly advisable that you have a conversation, you set the right expectations, especially when you are in a healthy and a happy union like a marriage,
Mm.
that you have the other person know, or even your own children, um, that this is what I've created in my will. I'll give you an example.
Mm-hmm.
My parents were married out of communal property.
Okay.
Um, Prior to my dad passing away, there was a conversation months before, actually, for years before we knew that, he might one day pass away. There was a conversation, and
Okay.
where my dad sat us down and said, if I should go first, everything in this house that I own belongs to your mother. I will
Okay.
give
Oh, he
you,
had it with you, the children.
yes. And he said, I
Oh,
will
okay.
give you something in my estate, but just know that this house and the cars belong to your mother. And my mother had the same conversation. So months or years later, when our dad passed away, none of us were taken by surprise by what was in our father's will, because there was a
Okay.
conversation. And I believe those kind of things comes down to open and honest conversations. And one supposes that those conversations also take place in a context of a healthy family environment. Now, when you already have tensions between family members, whether or not you're honest or not, let's be honest. Once a person is
Mhm.
dead, in the grave and cold, family members will come up with, with all sorts of stories.
Yeah.
And that's
Mm-hmm.
why the will becomes important, because if it's dated and it was executed validly in terms of the Wills Act, the chances of disgruntled family members being able to dispute, contest the contents of a will are very slim. And in that case, if I was the executor of such a will, I would say, you want to dispute this, you dispute it at your own cost. You want to contest a will, you contest at your own cost. Because remember that any legal process in our country is costly and it's time consuming. And so, if somebody wants to come forward and contest the contents of a will, it is very clear that they must do so with valid grounds, and it can't be on some flimsy. I don't think he was of sound mind. You must actually have valid grounds for wanting to contest a will. Otherwise, it becomes frivolous. It becomes a waste of time and money for the
Okay.
executor and for the estate in itself. So it's necessary that you have these conversations to avoid uncertainty, and so that when death occurs and family members are left behind, there's certainty around what actually wanted to happen in my will and or
Yeah.
with my estate after one's demise.
Okay. Thank you for that. My next question will be: how does wills? Yeah. How does it affect common law marriages?
So interesting enough, we have this concept of a common law marriage,
Yeah.
but
Maybe you should explain what common law marriage is first. I know we spoke about it in the other interview, but maybe you should explain it first. What is known? So Because somebody might be watching and think they're married. They actually is not. It's a different kind of marriage. Okay.
Yeah. So if we think about it from the proper construction of a marriage,
Yeah.
a common law marriage supposes that two people are just cohabiting together. They're just staying together, giving each other the rights and powers of a husband, which are not recognized in law, and that's what it is.
But how long do
So
you have to be together? Because these days people moving at the drop of a hat. They living together at the drop of a hat. So how long do you have to have been together for it to be considered a marriage, a common law marriage?
well, we don't have a law that stipulates that. So people can stay together, and when the other one passes away, I would have left my will, and doesn't mean that the other person or party to this common law marriage has got any right. Um, except for, interesting enough, which is an interesting concept in our law, except for um, when it comes to pension funds, when somebody was considered a dependent, a financial dependent on the
Yeah.
person who passed away, that's when
Hmm.
the definition of the word spouse is then extended. But ordinarily, we don't have such a concept, or the concept of common law spouse is not really recognized, because what you see in practice is the minute you're not married with a person and you stayed with them and you are supporting them financially, or you supported each other in terms of your career goals, if that person was not legally married to you, sorry for you, you actually not,
Sorry for you. Oh
yeah,
dear.
yeah. So it's beneficial that people understand what they're getting themselves into and what
Hmm.
rights really are afforded
Yeah.
to their arrangements, just so that you don't end up with nasty surprises when death occurs.
Okay. So, still going on the things that could affect a will. What about religious laws, like maybe Sharia law? Does it supersede the will? I
So
asked
as I
this
mentioned,
because, sorry, let me just finish this. I listened to a woman on the radio who started a business with her husband. So it was their business. That was it, basically. And they were married under Sharia law. But when he died, his family came and said, and threw her out, basically. It was a thriving business. And she just didn't think it was going to even come up. The idea that she doesn't own any part. She didn't get anything. She was totally out of the whole inheritance, and he didn't leave a will. So where does the will and the religious law come in here?
so let me go back into memory. So according to Sharia law, if I
Yeah.
if I recall properly,
Mm.
marriages are automatically out of commit of property.
Hmm.
So what the husband owns, and what the wife owns. What happens is, even in terms of Sharia law, there is a certain prescribed way
Okay.
that a married person, or a married husband in this case, there's a hierarchy of inheritances that you leave. And it starts with what they call religious death in Sharia law, and then it moves down into, according to Sharia law, that certain males inherit more than female beneficiaries. So
Hmm.
in that instance, one would have to ask the question as to, did the family doing that, did it meet with the tenets of the particular faith? But insofar as South African law is concerned, provided that what is contained in the will that aligns with Sharia law is not against public policy, then you will find it very hard that the South African law would seek to intervene in that situation. Because remember, we spoke about freedom of testation earlier
Yeah.
when we started speaking. And then we said that the only instance when freedom of association is going to be limited is when it is against public policy. Now, even with religious law, we still hold it against public policy. And most religions in the world, they don't condone the killing of other people. They don't condone criminal acts. So, provided that what is contained as per the prescripts of Sharia law is not against public policy, you're going to find yourself that the courts are not going to intervene. But in a situation where you are a spouse married according to Sharia law or Muslim law, and you are not inherited, look, one could still contest on the basis of if I'm a spouse in such situation, one could still contest on the basis of maintenance because by law, the two spouses are obliged to maintain each other and even the minor children. But I'll be honest once again, I've not seen many where a Sharia will has been contested on the basis of maintenance. And I think it's mainly because it is understood that within Sharia law, that if a man's brother is to inherit more from his estate, it is understood that the principle for doing so is so that they are actually taking care of his.
Oh, okay. Okay.
Yeah,
That's a big
that's a big,
trust, eh?
yeah,
That's a big
that's a big,
trust that it's going to look after your children when you're not there, you know?
yeah, yeah.
Mm.
So that's the base upon which Sharia law or Sharia law of succession is based on. That
Okay.
if a man passes away and is survived by a wife and minor children, his father or even his brothers will inherit a bigger portion of the estate. And the main purpose of that is so that they can actually continue taking care of the children or even the surviving spouse of a deceased brother or son.
This is quite interesting. I assume that this is not just about Sharia law. It will have to do with all religious laws. You'll have to bring it up and look at it. That it meets with with whichever country it is, with the country's laws concerning inheritance. But I
Yeah.
was just reading yesterday. What we know today as Nintendo, when it started, the man that started it didn't have any male sons, male children, so
Yes.
he arranged a marriage. A Japanese guy. There was an arranged marriage for his daughter to marry a particular person, and apparently, I don't know if he's still the loner, but then because we're talking. It's 130 years now, which is what I was reading. I mean, the company started 130 years ago. And what happened is he then adopted the 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 husband that he picked for his daughter, and then he could leave the company to him because they were not allowed to leave the company to they were not allowed to let girls were not allowed to inherit. That's what I'm saying.
Mm.
So and it went on and on because I think that happened like three times. That couple didn't also have a male. The man that was adopted into the family then had to look for someone else to marry his daughter and take the name because you have to actually take the name, adopt the guy, and it's been continued well until now. There's someone, I don't know if I would say someone who's a direct descendant, but at one point they actually had a son in the family line. So the company has continued like that rather than the company closing down. They had used that loophole because I would see it as a loophole. You get a male into the family, adopts that person, takes your name, and then becomes your family. So instead of the wife taking the name, the husband. It's interesting how inheritance go.
So,
So
so,
who
so,
can contest the will? Okay, no, sorry, go on.
so I wanted to link up the issue of females not inheriting. Remember that also in the
Mm.
Bible we have in the Mosaic
Those five
law,
girls, yeah. Hmm.
yes, who took an issue
They have to fight
Moses
for their inheritance. Yes.
yes,
Mm.
but the
Hmm.
inheritance. And I
Yeah.
suppose, although we're not talking about gender rights or women's rights
Hmm.
today, I
Hmm.
suppose this issue of patriarchy really, really goes back a long way. And we really have got to apply our minds as to what society do we live in today. Today, in a South African society, women are afforded the same rights as women. Although we know, I
I
mean,
think it's still a man's world.
yes,
Some
it
laws have
is.
not changed. Yeah, I think it's still a
Well,
man's world.
in the
I hear
public
you.
space, a lot of
Mm-hmm.
laws have changed, but a lot of what you're talking about when you talk about traditional views and
Mm-hmm.
religious tenets that affect inheritance or succession law are still very much steeped in patriarchal values that
Yeah,
we live. And so that's why you really have got to be of sound mind. You really have got to approach the issue with um, a real intent around creating that equitable space, particularly for your daughters, if you're a man,
yeah,
with daughters, and even as a female, I've got to make sure that I take care of my daughters, um, to because to your point, sadly, it's very much still to some extent still very much a man's world. So we need
yeah.
to make sure when you are creating a will or a trust, you take into consideration the fact that in some uh, certain aspects of our society,
Yeah,
women's rights are not necessarily that upheld.
yeah. Now this is very interesting because anyway, who can contest the will? Who in the family can contest the will?
So I'll use an example of a married couple with children.
Mm-hmm.
Um, if the man goes first, if the man passes away first, the children or the surviving spouse can contest the will only under those conditions that I mentioned earlier, where
Okay.
they are of the view that the person who made the will, that in this case the
Mm-hmm.
husband or the father,
Or the
was
wife.
not of sound
Mm-hmm.
mind, where they
Okay.
think that it's a forgery, the will is not the one executed by the father. Maybe they've got information around, when the father might have or might not have executed a will. If they think that um, he did not apply his mind in terms of the inheritance that has been left to them.
Yeah.
So in that type of scenario, it's the family members.
Okay.
If one is an unmarried person, but with children, your children can then contest a will if there's legal ground, or your own siblings can contest the will, particularly if one is unmarried and does not have children, and I go and leave my estate to strangers that my family does not know about. You will have enough ground to say, what basis would my sister go or my brother go and live access to people that we don't even know about? Even if we know about them, on what basis would you want to go and go and leave your estate to other people? So it is the broad definition of who can contest the will. It is anybody with justifiable interest in the world. But obviously, not any man in the streets, in the scenario of
Okay.
not any man in the street can say, this is the world, because what interest are you, rights are you seeking to protect?
I'm laughing because of this justifiable interest in the will. I think if I make my own money and all these assets or whatever it is that I am leaving behind belong to me, I should be able to decide what I want to do with it. And I find that you find that you read about I don't know anyone who they've not been interested in this person. They just you know what, when grandma goes, we're all getting something. She's rich. But you're not interested in grandma. You've never gone to see her. You've never, you've never paid any. You're just waiting for the day she'll die. And then you're surprised. You're surprised that you're not named in it. And I think, who are you to contest the will? Don't I have the right to leave my money or whatever it is to whoever? I know some people do make some. They're like, really, you couldn't find anyone else that needed this more than the dog or something. You get what I'm saying? But
Yeah.
yeah, you know what I mean.
You know,
So
I-
another pet,
so
yes,
let
go
me
on.
just share something with you. That's
Mm,
very interesting. You
mm,
know, in certain sectors of our community, We have
Yeah.
situations where the elderly are taken care of by their domestic helpers.
Mm-hmm.
Um, and in that instance, I've seen instances where an elderly couple or an elderly man lives his entire estate to the domestic worker and her family because they will
They were
say,
the
"But
one
my,"
looking after them. Yeah.
they will look exactly.
Mm-hmm.
Um, in such cases, yes, I'm sure the family would have good enough reason, according to them, to go and contest the will. But if it's
Mm.
found, particularly, and that's where the issue of witnesses becomes so important, because a witness
Okay.
can then be called as a credible witness during the court case that this person was of sound mind when they were making their will. So
Hopefully
you
the
do have,
witness doesn't die first.
hopefully, yeah, yeah. But
Because
that's
if the
when,
witness dies, what do you do?
then you've got a problem because the person who witnessed the will is no longer around. But then
Yes.
that's when it becomes important that in such situations you review your
Mm.
will regularly, as a
Okay.
person with the will.
As life goes
Because
on.
as life goes
Okay.
on, you review
Yes.
your will regularly. Yes.
Okay. Okay. That one actually is what is really necessary. Before I go to my question on desk duties, there's something else that again it's males that do this. I don't know if women do it, but where you have beneficiaries say to your pension, to your life insurance, whatever it is, you leave it to, like you said, like maybe a brother with the belief that they will look after your children. And before you die, you have a fallout. And this I know from personal experience. You have a fallout with this person, but you forget long ago that you've left them as your beneficiary. So when you do die, they collect everything. You haven't spoken to them in decades. What happens? And all the what the family is thinking is, oh, you just died, you didn't even leave anything to it. Meanwhile, there was something left, but ties have been cut with this other person way before, so you don't even know anything about it. Do they have a do they have an obligation to come and say, actually, this is your father's money or your mother's money? Do they have an
Yeah.
obligation to do that?
So see, that's when I we start the conversation with saying public morals. And public
Mm-hmm.
morals are generally based a lot on the tenets of a lot of faiths around the world, right? Which
Okay.
is honesty and integrity. So, legally speaking, if one has got a policy life cover and they make
Mm-hmm.
a brother or some other person a beneficiary on the basis
Mm-hmm.
that when they pass away, that they will use the money to take care of their family. Two things come into play there is that beneficiary nomination in a policy that cannot be superseded by a nomination that I have in my will for the same policy. For the same reason that an insurance policy is a contract that
Mm-hmm.
an insurance company, let's say Old Mutual or Sanlam, gets bound by.
Mm-hmm.
So a Sanlam or Old Mutual or a Momentum will be obliged to honor what is in the contract, where I've elected or nominated my brother or any other person as the to receive the proceeds of the life cover.
Okay.
Now, many people make this mistake of thinking that what is later contained in the will supersedes what is in the contract. Understand that the one is a contract binding the other people. That is an insurance contract.
Yeah.
You by electing
Mm-hmm.
a beneficiary or by nominating a beneficiary, it's something that the insurance company becomes bound by, as
Yeah.
opposed to a will, which is a document that I, of my own accord, set
Mm-hmm.
out and I say, this is what happens in it. So a will, by legal definition terms, is called a unilateral contract or unilateral document
Mm-hmm.
that I
Yeah.
make on my own.
Mm-hmm.
And so
Mm-hmm.
the two don't talk to each other for the most part.
Okay.
Um, because the one is a contract binding the insurance company, the one is a
Mm-hmm.
contract that I make on my own, to which I'm binding my executor to adhere to it only after my death. So in that
Okay.
instance, when you were perhaps naive enough to think that a family member, a friend, or whoever will use the money to look after your family after your death, well, you will suffer the consequences of being naive to think that they will do that
Especially if you
because,
don't leave a will. And then
yeah,
so
give the
it's
money
so
to run
it
with.
will, yeah. So it will be the onus will be on the person to say, actually, he left this, for me to take care when we were still on good terms. So let me tell the family, I've got some money for you guys. I kind of don't see it, but okay, maybe it will happen. Maybe it will happen.
Yeah.
Oh boy. I hope you're getting your questions ready. I've still got some more questions here, but we'll take your questions after say in another 10 minutes or so. So, Mathlodi, what are desk duties? Why do government you take part of my money?
There's a
Because that's what
saying,
it is basically, isn't it?
yeah.
What are
There's a
desk
saying,
duties?
yeah, there's a saying that there's only two things that are inevitable in life. That is death and
Mhm.
taxes. And so,
I like that one. Death and
yeah,
taxes. Okay. There are
yes.
people not paying taxes, my darling. There are so many people not paying taxes, but okay.
Well, yeah, I mean, I believe those people, the law will soon be closing in on them. But
Okay.
anyway, in South African law, we have only one type of death taxes, which is estate duty, which
Okay.
is a levy or a tax that is levied on your estate, but only if your estate is above a certain amount. If say it's about 3.5, 3.5 million, then anything above 3.5 million, SARS, the South African Revenue Services or Authority, is able to levy 20% of anything above 3.5 million on your estate. So that is
Wow.
the one form of estate duty. But there's somewhat of there's a beauty in that it's the estate that pays the estate duty, and so once the executor has wound up the estate and they paid off the estate duties, what comes into the beneficiaries then does not get taxed. So that is the one form of death duty. Other countries, um, they
Sorry,
have
that sounds, I'm interjecting, but I don't want to forget. That sounds like gross profit and net profit kind of thing. So is the desk duties is worked on the total amount that you have left? Yes.
no. So remember that if my estate is below 3.5 million, I don't pay
Mm-hmm.
estate duty. My
Okay,
estate
so
will not
let's
pay duty.
okay, so let's say the estate is 4 million. Who
Yes.
does this value? Because I'm assuming the estate means property, money, everything added together is like 4 million. Okay. So the 20% that is going to the government, is it yeah, that's what I mean. So it's like gross profit and net profit. So the 20% is taken out of that 4 million. And then when you get what is left,
No.
you're not taxed over it again. Or are you
No.
taxed again?
So anything up to 3.5 million is
Mhm.
tax free. The difference between 3.5 and the value of the estate, let's say from 3.5 to the total value of the estate is 1
Mhm.
million. It is only on that
Mhm.
1 million that you get,
Okay, okay, okay,
but
okay,
only
okay.
20% of that. Yes.
Of that. Oh, okay. So let me use
Yeah.
my 4 million again. So if the estate is 4 million, you're only going to be taxed 500,000. That is
Yes.
over the 3.5.
Only
Okay, okay,
20% of that. Yeah.
okay, okay. I
But that's a
understand.
simple way of
And
looking
then,
at it. A
mhm,
technical way of looking at it is when we say, even in that, there are certain deductions that SARS will allow the executor to have or to make to actually reduce even on that 500,000, what actually gets
Okay.
taxed. But that's a very
Oh, okay.
technical. Yes, yeah.
Okay. So if you're owing, which happens more often than we would like, but if someone is owing before the beneficiaries get anything, are the creditors paid first, or do you get your stuff and whatever is left is what is used to pay off your creditors?
So the creditors are paid first. So the duty of an executor is to wind up the estate, to pay off your creditors, and what
Any
gets left
outstanding?
then gets into the beneficiaries. And that's why the the that's why it is so important to have somebody who advises you and guides you to say, when I look at what you have as your estate, this is likely to be the the sort of expenses and your creditors that you will have, and this is what is going to be left, so that what I ultimately leave to my family remains intact. Let's say I want to
Okay.
leave to my family 5 million worth of inheritance, but
Okay.
I've got 5 million worth of creditors or of liabilities. That means that what goes to my family is zero, because the 5 million would have gone to pay off or settle off the debts. So it's
Okay.
important that you do proper estate planning, that you consider, what do I want to leave to my daughter, my son? Where are they in life? Are they still in high school? They want to go to
Yeah.
varsity. They want
Mm-hmm.
to start a business. They want to buy properties. And then you do proper estate planning and analysis of what you would need to have to be able to leave them 5 million after all your debts have been paid.
Okay. Okay. Okay, let's look at this question from Pratronella. So what does that mean practically? If all you have is a house worth 4 million, no cash, no liquid cash anywhere, do you have to sell the house to cover the estate tax? I'm assuming the house will be valued for 4 million, and then but that's all you
Yes,
have. It's just the house.
yes. And so I actually think that the question from Mrs. Paternal is a very good one. And that's where
Mm-hmm.
you'll hear me throughout. I advocate for estate planning, where in that scenario, remember that if I've got a house only and my house is valued at, let's say, 5 million, let's use
Yeah.
a 5 figure.
Mm-hmm.
For it to be valued, I'm going to have to get the service as an executor. I'm going to get the services of a valuator that must be paid.
Yeah.
I'm going to have to pay for transfer duties, for conveyancing fees, for the house to be transferred to my beneficiaries. And so those are all what is called administration expenses. And so then you've got then, the estate duty that you must pay. And then and a practitioner, estate planning practitioner, or what you call a fiduciary specialist, will then sit with you and say, if you only have a fixed property in your estate, we need some liquidity to be able to cover for some expenses that need to be paid upfront, particularly if we don't want the house to be sold.
To be
And
sold.
so there's
Mm-hmm.
various ways of creating provision for liquidity. One of the ways is by making sure that I have a life policy that pays into the estate, because remember, it's cash coming into the estate,
Yeah.
and
Mm.
that covers for those administration expenses. And to this Paternolla's question, that will also cover, hopefully should cover, if you've done proper calculations, that should also cover for the amount of tax that must be paid to SARS as a state duty. So it's advisable that if you only have a fixed property, and you've done your will in conjunction with advice from a practitioner, as an expert in the field, that they'll also guide you to what you need to do to create liquidity in your estate, that you pay for the expenses that will need cash. Particularly if
Mm-hmm.
you are clear that my house, I don't want my house to be sold. It's a family home. I want my family to continue living it after the death of the person who's making your will. So that's a very good question that she's asking. And so the way to get around that challenge is by leaving money, leaving cash, or at least taking out a life cover to create liquidity in your estate to cover for the administration expenses.
Okay, she's got another question that I think it's a good thing to. What is the law around living wills in South Africa? But maybe you need to first let us know what a living will is.
Um, a living will is one way you say to somebody or to your executor that if I should get to a state where um, I am not able to take care of myself. So let's say, for instance, you get Alzheimer's or you get dementia,
Mhm.
then who will continue to be of assistance to you? But then it gets technical because remember at the start of the conversation, we started talking about legal capacity. And so we said that in terms of South African law, a child who reaches the age of 18 attains legal status or legal capacity or mental capacity.
Yeah.
Then we also got a concept that says that if somebody gets to a state where they are not of sound mind, and you mentioned that a lot of the words that we draft will say, I so and so of sound mind. Now, if I get to a state where I'm not of sound mind, that means that I have lost my legal capacity, so that I need to be assisted by somebody. And so
Mm.
by law, you then have what is called a tutor or a guardian who steps in to
Okay.
look after your affairs. And so a legal will make sure that, things like that, when you're still alive, but you're not necessarily of legal capacity, that you've actually paved the way for somebody to step in, a family member to step in as a guardian or as a tutor to help organize your affairs. And so that's what a legal will does.
Okay.
However, and I know that most people would say that, you know, a legal will or a living will, does it mean that if I get to a state of terminal illness, that I can give someone the right to commit assisted suicide? Now, that's a very controversial issue in our country, which
Is it
is
legal
why
yet? I don't think it's legal yet. Is it legal yet?
no. But in other
I don't.
countries, particularly in Europe, it is legal. So I think we must just distinguish between what a living will can do, and versus
Mm.
what a living will cannot do. So in
Okay.
cases of what is called euthanasia or assisted suicide, in our country,
Mhm.
still very much frowned upon. Yeah.
Yeah. Okay, there was a question up now. Someone asked a question, what if both parents die? Before we go to Portia's question, Emmanuel, can you put that question back, please? What if both parents die, no will, but there's estates? All the kids are also not minor, so adults, children, all the parents are dead. There was no will left behind by either one of them. What happened to the estate? Who will
So
decide?
So remember we spoke about earlier. There's a law in South Africa, Interstate Succession Act.
Mm.
So that decides who, in that instance, inherits. So parents pass away. There is no will. Children are not minors. So in that instance, those children will inherit in equal shares the estate of their parents. That okay. So
Okay.
so maybe I need to qualify this. Maybe I need to be get practical. It does not
Mm.
often happen that parents die at the same time, unless if it's a crime or it's an accident. So generally, what happens is um, one will have passed on before the other, and then in that instance, what you need to do is you actually need to administer the estate of what is called the first dying, the first parents who have passed away. And if they died without a will, the law of Institute Succession Act comes into play. So there's a certain criteria or hierarchy as to who inherits. Now,
Okay.
suppose the one parent passed away, their estate was not dealt with. And only when the other parent passes away, only the estate is dealt with. Then it needs to flow from the first parent who passed away through to the surviving spouse and the minor children. And ultimately, the portion that went to the surviving spouse will then ultimately go to the surviving children. So it
All
doesn't
right.
happen in practical terms that two parents die at the same time, or parents die at the same time. They're generally the first one who
Mm.
passes away, unless in scenarios that I've mentioned where it is um, in a crime situation or in a car accident or some other type of accident that it
We
is said
had
that
this
they
happening
die.
during COVID, though. Quite a number
Yes.
of people lost families like that in COVID. And because I don't know if this is a black thing, we just don't think to write our will, you know. We just think there's time, or just like if I'm writing my will, it's almost like, okay, I say I'm facing the reality that I'm going to die, even though we know we are going to die. So okay. So let's go on to trust.
Okay.
If you have any questions on wills, please send it in, and we'll see if personal. Sorry, if Mathlodi will be able to answer it before we're done. Yes, but yeah, we're learning that liquidity is very key now. So, what is the trust? And I don't want to say this, but I think you can please correct me. When you set up a trust, no, tell us what a trust is first, then I'll ask the question. Okay, so what is a
Okay.
trust?
So a trust is a vehicle, and I'm calling it a vehicle for lack of a better word,
Yeah.
that I create that is going to house assets. Um, in legal technical terms, a trust is almost equated or likened to a company.
Okay.
So in our South African law, a trust takes on what is called a legal personality. It
Okay.
becomes an institution on its own. So a trust, you have different types of trust. So you've got family trusts, you've got business trusts, and you've got what we call BE trusts in South Africa. But for the purpose of our conversation today, which is focusing on
Family.
families,
Mm-hmm.
a trust is then an institution that is created to house assets where I, as Mathlodi, I'm setting up a trust today and I'm saying my house, my investments, or any other property that I have are now in the trust and I'm creating them so that my family and generations after can enjoy from the assets that I'm putting in a trust. And but the benefit of a trust is that the assets in the trust are then owned by and owned not for their own benefit, but owned from a legal perspective, are then owned by the trustee
Interest.
who looks
Okay.
after
Mm-hmm.
those assets for the
Mm-hmm.
benefit of my beneficiaries. Then what happens is because the beneficiaries in the trust don't own the assets straight away, unless if I've made a condition in the trust deed, which is like your constitution for setting up a trust, unless if I make a specific condition in the trust deed that when my son or any of my children reaches the age of 25 or whatever the case is, as I deem fit, I will then say certain assets, when they reach a certain age, will vest in them, meaning that they will then be transferred from the trust into their own names. Or I
Okay.
can say my children would only enjoy the benefits of these assets in the trust, and the trust will run in perpetuity for generations to come. And that's
Okay.
why trusts are called family planning or legacy planning vehicles, because they
Okay.
allow for the continued um, benefits to be enjoyed by the family of a particular individual for as long as the assets are still intact and we don't have instances where the money has been depleted, because it does happen that the money gets depleted or the properties are destroyed by fire and all those catastrophes. So
Okay.
you then create a trust for the benefit of your children and your children's children,
Mm-hmm.
who will then continue to enjoy those assets in a trust.
Okay.
Yeah.
Who can set up a trust? I mean,
Similar
anyone?
to similar to a will, the
Mm-hmm.
minute you've got assets, the minute you've got a wealth, for those of us who are still acquiring assets, you can set up a trust for the benefit of your children. But we then make these two distinctions. Remember that at the start of the conversation, I said you can create a trust in your will called a testamentary trust that only
Okay.
comes into after your death. Or you
Mm-hmm.
can create a trust today, which is by means of a legal contract, um, that comes into effect today and is called inter vivos trust. And I transfer assets into it while I'm still alive. With your testamentary trust, which is created in your will, you create assets, you transfer, or assets are transferred into your trust only after your death. So,
Okay.
any of the people that we just mentioned with assets, with a need to create a legacy for children and for their children's children, can create a trust. Anybody
Okay.
who has got, let's say, somebody who doesn't have children wants to create a trust, and they say, I'm creating a trust because I want to create a foundation to
Okay.
fund um, education for versus students at vets, at UCT, wherever. I can create a trust, transfer assets into it, and I entrust the monies that I'm transferring into the trust to trustees to invest them, to grow them, so that my objectives of benefiting university students through funding are
Okay.
realized.
Mhm.
Yeah.
Okay. I was going to say something. I think that's been a bit flippant, so don't let me say it again. I'd been told before that you need to have assets, other cash or whatever, worth five, no, 7 million, 7 million rand before you can set up a trust. But I don't think that's true. I mean, if you have, like we're saying now, say you have a life insurance policy, and you have minor children, could you not link that together so that the money from when you die, there's something for your children, which your will will state. You understand what I'm saying? So it's not I've left wherever it is on as a beneficiary. I left, let's say I leave a minor as a beneficiary. As of the time I was setting up the trust, this person was a minor. Now I I die, and unfortunately the person still has not reached the age where they can take the money. Can you not have that in your will to say, until the age of 25, that life insurance money must not be paid out? Well, I will talk about, we'll ask questions now about the trustee and executor and all of that. But is that not possible? Before we take Portia's question, is that not
So
possible? Did I
can
say
you
it correctly, or was I waffling all over the place?
maybe just for some clarity, you're
Okay,
asking,
so let's say I have a life insurance of 2 million,
yeah.
and you okay, let's say somebody has a life insurance of 2 million, don't want to die yet, and they have left it in the beneficiary as their children, right? Now the person dies before the kids are 16, for example, so they're not old enough to be given that money. I don't, and you've left a will, put in the will that until my child is, or until this person, whether the first child, the third child, whichever one, is 18 or is 20, whatever it is, they are not allowed to have possession of that money. Can that be done? I mean, it's 2 million, it's not seven, because this, I heard this from someone who said it, when people say something categorically, even though they're wrong, that you've got to have 7 million before you can set up a trust. But what I'm hearing now is different. I don't have to have 7 million before I set up a trust.
So look, so the issue of assets and how much assets, the quantity of the assets,
Mm-hmm.
becomes important if you consider the expenses of running a trust. So you
Okay.
must have a trustee who must be paid annual fees. You will have to pay income tax. Remember, I said to you that a trust is a legal personality in South African law, and a trust pays taxes.
Mhm.
And a trustee will have to also hire other specialists to help grow your assets. So in that sense, a trust becomes not an inexpensive vehicle to run. So that's when people will put a certain amount of money into
Okay.
what is the minimum, because
Minimum.
it's not
Okay.
an inexpensive vehicle to run.
Okay.
But your
Okay.
question is, if I have got a minor children, a minor son, minor children, and I've got a funeral, no, no, a life cover of say 3 million,
Mm-hmm.
and I am nominating my children in the will, and sorry, in the policy
In the
as
policy.
beneficiaries, in the
Mm-hmm.
policy as
Yeah.
beneficiaries. Remember what I said earlier, that nomination in a policy supersedes what I've got in my will. So the ideal thing, particularly if you do it with an advisor, they will say to you, don't nominate your children in a policy as beneficiaries if they're still minor. Rather have the money paid directly into your trust, and then what goes into a trust after your death, your children via a trust becomes beneficiaries of that.
Okay.
Because
Okay.
the minute, let's take my son who's 13 years old. In my policy, if I nominate him and he's still 13 years old, he's still too young to manage those assets for his own
Mm-hmm.
benefit. So, what I
Mm-hmm.
need to do is have the policy pay into a trust or pay into my estate that will then pay into my trust for his benefit, that trustees will run that or manage that trust for his benefit up until he's 18, 21, 25, or 30.
Okay.
Quite frankly, I don't believe that children at the age of 18 or even 21 or even 25 can manage their own assets. I'd
No.
actually say until he's 30. Then at least I know that he's had some failings in life, he's had some lessons in life, and he
Mm-hmm.
will, at the age of 30, he's finished his degree. I can even make a condition to say he will not have access to that money up until he's at least got a master's degree.
Okay.
And by so doing, I'm saying I only want him to have access to the money when he's proven that he's capable of
And he's
making the right
matured
decision.
enough to handle it. Yeah. Okay. Yeah. Yeah. I don't want to leave a money to a girl who then meets a boy, you know, and
Yeah,
then the money is gone before you know what's happening. Let's
yeah.
read Portia's. He says, "Are there any financial aids available for people who may have income generating assets in an estate that has debt due to no liquidity?" I'm not sure I understand. Do you understand what she's saying?
I think I understand what she's asking. So what she's
Okay.
saying is that she's got an asset that is generating income,
Mhm.
but in an estate, but she may want to grow the asset and realize its potential. Look, Portia, this is not my area of expertise, but I believe that there would be. There's various avenues that are available through investment banking, and even your normal banking products that will allow you to inject cash into your income generating asset for you to realize its full potential. But
Okay.
that question is best answered by specialists in this area, and
In
I'm
the
not a
bank.
specialist in this area. Yeah.
Okay. So I hope that helps, Portia. We go to the question of trustees and executor. I completely mixed these people up. I thought they were one and the same. So, what is the difference between a trustee of a will, or is it of a trust, and what's the executor of the will?
So an executor is a person who executes your will in terms of your wishes and then administers your estate. So the two are different. And then a trustee is somebody is a trustee, as the name would suggest, a trustee who acts in the same or similar capacity as an executor, but in this instance, in the context of your trust. And so, they afforded more or less the same powers by our law, that they step into the shoes, in the case of an executor, they step into the shoes of the deceased person in the case of a will, thereby an
Mm-hmm.
executor. And in the
Yeah.
case of a trust, they step into the shoes of somebody who is the founder, somebody who's creating the trust, and they step into the shoes because you give them powers and certain duties that they must make sure that are being observed.
Okay.
But I must say this before I forget. Remember that an estate cannot run indefinitely. So the executor comes in, does what they need to do for a period of 12 months to 18 months to 2 years. And then they transfer the assets to, they pay off the liabilities and transfer the assets to the beneficiaries. An
Oh,
executor, yes, an executor, because a trust can run for 5 years, a trust can run for the lifetime. Let's say I'm creating a trust and my mother is a beneficiary, and I will say the trust will run for as long as my mom is still alive. When my mom passes away, I want the trust to terminate. And
okay.
so trustee, it then becomes, only comes into the office for as long as my mom is still alive or my beneficiaries are still alive. Once they pass away, the trust, I will then say the trust must terminate. Or I will say, if so and so is still alive and they pass away, then the next beneficiaries is the following people. Then the next beneficiaries are the following people. So generally, a trust runs for a very, very, very long time. So
Yeah.
you can have a trustee in office for more than 50 years, even some, even for 100
Yeah, I
years.
was thinking of it, what you just, because I mean, those who really have a lot of money or who have
Yeah.
been wise with their investment can be like, for my children's children, for so long as they're children in my generation, so they get
Yes.
something. Okay. Now, how do you pick them? How do you pick an executor? How do you pick a trustee? I know some banks now, if not most banks. I know Standard Bank, I think, and I know definitely FNB. They offer will services. They write your will for you. I know. Is it automatic that they become the executor of your will if the bank is writing? Okay, so if it's not automatic, how do you choose? And is it advisable for the bank not to be? Because I'm thinking of, we all die at one point. So you're assuming that this person you've picked is going to outlive you. What if they don't? Things happen. So is
Yeah.
it advisable to only have an actual person, or to have a company who is, it's an entity on its own, so there will always be somebody, there's always be staff who will keep it going.
Yeah.
How
So,
do
so
you choose an
you're
executive?
asking me two questions. Does a bank automatically become an executor or trustee of your
Mm-hmm.
will or trust?
Mm-hmm.
Um,
Yeah.
the answer is yes and no. So many banks will say, we will draft your will for you for free on condition that we become the executor or the trustee. But you don't
Mm.
always have to agree. So you can say, draft my will, and I will pay
Pay.
a fee or a service,
Mm-hmm.
but I
Mm-hmm.
want somebody else to be the executor or the trustee.
Okay.
So it's not always automatic, but it's a
Okay.
default position that many banks will have. But then you go into the conversation, you ask questions as to, what are the benefits? Why must I have you as a default trustee or executor versus having the bank alongside my family as the default executors, co-executors? And then your other question was around, what was your other question, Sister Me?
Is it advisable?
All right. So, look, you're looking for continuity.
Mm-hmm.
The benefits with the bank is that banks have been in operation for
Mm-hmm.
hundreds of years for many of
Yeah.
them. So
Mm-hmm.
you are guaranteed that there'll always be somebody who is going to step in and do the work. Because remember that you're not nominating an individual but an institution. So the likelihood of an institution not being in existence is extreme, where a bank gets liquidated or whatever the case is.
Mm-hmm.
But also you've got the likelihood of experts being in those roles who will execute the trust or the estate according to your wishes and according to the law, as opposed to nominating an individual who, the day after you've executed your will or a trust, can pass away. Then you need to find somebody else.
Mm.
Um, and you also need to be certain that the person that is coming in as executor or the trustee has got the necessary skill set. So in our law, generally, attorneys become the natural choice for many people because I have a relationship with my attorney. They've got the
Okay.
skill set to do the work. But the problem becomes when if the firm of attorneys that I'm appointing as executors or nominating as executors in my will, the person is no longer around, or I have a fallout with them, and I then need to go find somebody else. Unlike
Mhm.
with a bank, even if I was to change my bank from one institution to another, I'm assured that that bank or organization will continue to be in existence for many years. And
Okay.
you also want
So,
to make sure that the individual that you're choosing has got the necessary expertise because these are very
mm,
complex work that they're
yeah,
called to do. Yeah.
yeah. So I will say it's advisable to have the bank and maybe someone else as co-executors. So at least
Yes.
if the actual person then passes away or for whatever reason you're not in good terms with them, whatever, there's still someone else who can do what needs to be done.
Yes.
And I went through all my questions. That was my last question. That was my last question, I think. But there's something that single people. Let me say, I'm using
Yes.
single. Whether you're, especially single women, tend not to think of the writing a will. You know, I men, maybe because we've always left things to men. It's just been that way. It is. If you are in a relationship, if you are in a marriage, whatever it is, you will assume that the man is taking care of it, or the man will take care of it. The man of the house will take care of it. What advice would you give to single single women, one, and then single parents?
Okay. So single woman is the one without children, right?
Just yeah, or
Yeah.
just single
So
people. Actually, let me not just say women, but I'm more concerned about the women.
okay, yeah, yeah. Let's say single
Yeah,
people.
not just the single
So
people. Yeah.
look, whether I remember at the start of our conversation, we said whether or not you've got children or not, I have
Mm,
assets that I want to be very specific about who gets what. So single with children, single without children, it is still necessary that you apply some thought. And I think even more so when you are single, because you might just have aunts and uncles and cousins who want to come lay hold to things that you've worked hard for, and you may have an
an
organization,
uncle
a
you don't
charitable
like.
organization, that you want to benefit from your estate.
Mm-hmm.
So
Mm,
it is nevertheless necessary that you consider, if I don't have children, who else do I want to benefit?
mm-hmm.
There's situations where somebody will say, I'm not married, I'm not planning to get married, I'm not planning to have kids. My sister and or my brother and his or her spouse, they are happy, they are well off, they don't need my money. I can maybe leave some sentimental items to my sister or to my siblings, but in terms of the real asset, I really want to leave this to a charitable organization. And that's something that then you are then well advised to consider. If you know that you're certain that you don't want to have children or you don't want to get married. Now, for single parents, be it female or male, I will propose and give a very strong advice that please have a will in place, especially when you've got minor children, because you don't want, in as much as in that instance, that the default position when somebody dies without a will, which is interstate succession act, comes into play, that your child will nevertheless inherit. But if a single parent has got a minor child and you did not create a will, guess what happens when a minor child must inherit? Remember, they don't they can't look after the assets themselves. And what happens is there's what is called a guardian's fund. Now, if somebody passed away without a will and did not create a trust for their minor children, what happens because um, there's no other avenue for securing the assets for the benefit of the minor children, the state steps in, and the inheritance of your minor child must go to um, the guardian's fund, and the likelihood of your 2 or 3 million growing to 10 million by the time your child reaches the age of majority is very slim because the investments in the guardian funds are not geared towards maximum growth. They're
It's slow and
only,
steady
yeah,
to
yeah,
keep it safe, to keep it
yeah,
safe.
yeah.
Mm.
So it is advisable that you have, especially for those with minor children, have a
Mhm.
will and please create a testamentary trust for them.
Mm. Before we read Kakiso's question, he did send it earlier. Still talking about single people. Well, maybe not so single now. Because of the way marriages are these days and the different ways you become a parent, surrogacy, sperm bank, adoption. There's so many ways. Adopt. Someone just maybe is living with you. Like in my family, there are always people living in my mother's house. We don't know where they come from, but they just live in their house. But so I'm just saying. But when your child and the family knows that this child is not blood. Say for example, a child that is adopted. What will be if you die without a will? What will happen to that child? Or if say there was you have a child through surrogacy, and then there's a divorce, or the partners decide to go their own way for whatever reason. What will happen to that child? What right will that child then have if the surviving parent, or whether by marriage, by divorce, by death, what will be the cost for the child when it comes to inheritance? Will the child be able to get anything? What will the law say about that? Because family, that's when they remember blood.
Yeah. So I can only speak from the perspective of South African law.
Yes,
So
please.
the child, in South African law, a child must be legally adopted before they can
Okay.
inherit from
Okay.
the estate of um, the parent who is now passed away. So it is necessary that there is legal adoption in place for that child. Um, and I think what you're talking about is when family members. I mean, in African culture,
Hmm.
everybody's family, and you're taking people. Sadly, according to the law that applies in South Africa, and I believe in many other African jurisdictions, is that there must be a legal adoption to create that right that they will inherit from the estate of the adopted parent. The same with what is called, or what used to be called, children born out of wedlock or illegitimate
Okay.
children. That they
Yes,
can
that's
also,
another one. Yes. Hmm.
yes, they can inherit from the estate of the parent, but in an instance where there's no blood relation and a child is adopted, there has to be legal adoption documents in place to entitle them to inherit from the estate of the deceased parent, and
Okay.
vice versa. If I adopt a child and the child passes away much later with assets, only if I'm the adopted parent can I inherit from them.
Okay. Okay.
Yeah.
That I actually didn't remember that scenario of a child who's been born out of wedlock, and sometimes there's a there's a funeral, and somebody gets up and say, that person is my father, or that person is my mother. And I know some families when the parents are getting to say, please tell us now, are there any surprise children somewhere we don't want?
Yeah,
And
no,
it has
that's true.
happened. And it's a reality. It
Yes,
has happened. Did this person just
yes,
comes and say, what part of the inheritance will belong to that person? Do they have to then go
yes.
do a DNA and prove that they're family or whatever? Oh wow. So we're going to
Yeah.
take this Kakiso's question as the last one. And if anyone has, I'm reading this out, and once Mathlodi answers it, that is going to be the end. So if you have any questions, this is the time to send it. Wow, Mathlodi, we've been here, even though we started late, we've been here over 1.5 hours. Thank you so much for your time. So let me read this. Can a will be corrupted? In terms of multiple beneficiaries and the other faction decides to collude to side on the sideline, I think he wants to say, with one of the beneficiaries. If there are
So
multiple beneficiaries and one of them decides, will it mean that it's corrupted? Wouldn't that be somebody changing the
no,
will? Is
I
that
mean,
what it means?
and I think the term corrupted is not one that
Mm,
we have in our South African law.
mm,
But I suppose what Kakusha wanted to ask is, can a will be invalidated? I'll take a
okay,
guess at that.
okay. Mm,
Um, yes, a will can be invalidated. Remember, if it does not, or not can be invalidated, but a will can be regarded from the onset as not being valid if it does not meet the requirements of Wills Act. And I've mentioned that the Wills Act says a will must be written, signed by the person making the will, dated, and have witnesses. Now, if a will doesn't meet any of those requirements to create certainty, then one can say that a will is potentially invalid. Now, on the question of multiple beneficiaries, look, if a will is in place and it creates certainty around who's to benefit what, the likelihood of the one faction of the beneficiaries colluding against others, especially when you have a professional executor in place, the likelihood of that happening is very slim because when you've got a professional executor in place, and especially when you drafted your will or you were executing your will under the guidance or advice of a professional, such scenarios would have been anticipated and you'll be guided to draft your will to minimize the impact or the success of such collusion. It's not to say that people will not try. Human beings are a very interesting species, and they will try, but it doesn't mean that they will succeed, especially if you do it under the advice of or guidance of professionals.
okay. There have been really wild stories of people going for a funeral. They come back, someone has changed the locks in the house while they were at the
Yes,
funeral. I'm like, how do you do that? They've changed the locks,
yes,
they've moved the cars out. You can't find the cars when you come back from oh my word.
yeah.
So Portia is saying the guardian fund is an option I reckon we should avoid. In addition to the slow growth, the procedure can be very tedious. What
I
procedure is it? The
agree.
getting it or the getting the money out? Which of the procedure? I don't know the
I think
procedure at all. Mhm.
I think what Portia refers to is remember that up until the executor transferred the money into the guidance fund, then the process with the executor is meant to run smoothly, unless if you've got challenges with that. The minute the money gets transferred into the guidance fund, I personally have never tried to get money out of the guidance fund, but I hear, and this is after 17 years in the industry, I hear it's a very tedious process. Um, you must go to that office, and that office filled in these forms. It's a very tedious process. And so, in practice, we don't advise our clients to go and live inheritance for your minor children so that they can go to the guidance fund because you really, really want to avoid that.
Mm,
You really, really want to make sure that when a child needs money for medical care today, for school fees, for school clothes,
mhm,
or any other thing, that
mhm,
they've got a person that they call. And if possible, in less than 24 hours, the money is available in their bank
Mhm.
account. So you really want to
Mhm.
avoid that. So I agree with
Mhm.
Portia. It can be a very tedious process, and one which I don't imagine that as a caring and loving parent, you want to leave
Mhm.
that option to your children. You really want to
Mhm.
avoid that. Yeah.
Yeah, yeah. Thank you so, so much. I think we covered much more than we did the first time. I'm not sure
Yes.
there is any other question that we have not looked at, whatever angle it is. And if there is, no, just give us your last word on this, on wills and trust.
Um, at the start, we said that it's quite interesting that we're having this conversation on Heritage Day, on the day that in South Africa we celebrate Heritage Day.
Mm.
And so I think if we take along the themes of it, of heritage, inheritance that you want to leave for your children, my last words or parting words or thoughts are: take the time to plan for the legacy that you want to leave for your children, and make sure that you consult with a specialist in this regard,
Okay.
and make those plans, because we've seen a lot of sad stories when parents have not taken the time to plan properly for their children, even for their own families. And we've seen the misery that gets left behind when people don't have these necessary conversations around what happens after their death, and the amount of family fights and squabbles and just people who are generally getting along as a family because a loved one has passed away. Suddenly they are fighting over assets. It becomes really sad,
Mm.
and it can be avoided.
Mm. Mm. And I would say, please, no matter what age you are, if you have anything you want to leave, I remember when Prince died, Prince the musician, and it
Mhm.
turns out he didn't leave a will. And this guy was what, if not a billion, but a lot of millions,
Yes,
in cash, in his record, in intellectual property. And that's one thing as well. Your intellectual property, the things you've invented, the things you've written, they are also quite valuable. And I don't know why he
absolutely,
did that. I think he probably just said, well, I'll be dead, they can do whatever they like. I'm not really sure why he did that. So it doesn't matter
absolutely.
what age
Yeah,
you are. If you have a child, I will actually say the same way, especially with parents, the same way you go and look for that school that you want your child to go to and register them, you need to look for a lawyer and sit down and write your will right there and then. Because
yeah,
yes, we all want to live very long, but we don't know when anyone is going. You need
yeah,
to make provision. It's I think it's an obligation. If you have a child, it's your obligation to make sure that that child, those children, are being well looked after, even when you're not there. And something else, I think, when you have a will, um, and if you have minor children, say exactly what you want for your children, because there have been people who are executors to the will, who are living well on your money while your child is managing. So you need to be very specific. So don't try to do it on your own like I tried. Do it properly, and it's actually painless. It's painless. Do it properly, get it done, and rest assured that you've taken care of your loved ones.
yes.
Thank you
We
again,
always say
Mathlodi.
we always say it's a way of giving clients peace of mind that
Mhm.
if they're no longer around, their affairs are in order.
Yeah, yeah,
Yeah,
can imagine that.
yeah.
Thank you again. It's
Thank you so
been,
much.
and for all those who tuned in to listen on my channel, on Pastor Tim's channel, thank you for listening. Thank you for joining. And I'll see you next time. It's been Coffee with Timmy. Bye for now.
Bye bye.